Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing the K-1 fiancé visa process, and we're discussing this in the context of the interview. I get a lot of emails, especially toward the end of the process. It's been more frequent lately because, quite honestly, COVID put such a backlog on all these cases, and as a result, we've just, I get it. People are anxious to get these cases resolved, to get their loved one in the United States. I totally understand the sentiment. So don't view this video as me critiquing people or even really having any issue with the applicants or the petitioners. My frustration is with the process, and my frustration is with the bureaucracy which has decided to make this process as difficult as it is and as time-consuming for no real reason, by the way. There's no reason why we have all these redundant processes in the K-1 process, why the backlog is what it is. In my mind, it's just bureaucracy run amok, quite honestly. Now, that said, you get to the interview, I get these emails where it's, hey, I'm coming into town to see to it that all of this ends smoothly. Yeah, that doesn't matter. I get this from sort of the American petitioner, like being on the ground is somehow going to change how this thing works. It doesn't. And the interview is not de facto and it should not be presumed to be the end of the overall process. And we're talking about the interview which occurs at the U.S. Embassy here in Bangkok regarding a finalized K-1 visa. They don't have to approve it on that day. And in fact, they can issue what's called a 221G, which is a refusal pending further documentation. That happens rather frequently. It's not, not out of the ordinary to see a 221G issued. And again, as we've discussed in other videos, the petitioner cannot go to the interview with the beneficiary. They'll be barred from doing that based on, they'll cite all types of things to not let somebody come to that interview because they don't actually, theoretically speaking, they don't really have a right to be at that interview. The only person who can attend that interview, generally speaking, is going to be the beneficiary. Now, from time to time, we deal with very complex cases, matters involving inadmissibility. I may make an appointment, go down and talk to the embassy directly regarding an underlying case, but for the most part, that's pretty rare. What we usually see is the beneficiary goes to the interview, that person is interviewed, and then either an approval, which is usually what you're going for, obviously, denial, but you're going to want to see some sort of legal ground of inadmissibility for a denial, or a 221G. So the interview is not the end of the road, as they say, with regard to the K-1 process. Presuming it is, you're going to make some bad decisions, in my opinion, in terms of, well, I'm going to go over there. No, you're not going to have an impact on the interview. It's not going to change anything. Coming here, you're really just going to spin your wheels at the end of the day. So my true position on this is, and what I tell clients is, okay, maybe don't, you're not going to have any impact on the interview. Now, if you want to travel over once the visa is issued and travel back to the United States with your loved one after the visa is issued, that's not a bad idea. But to show up before it issues at the interview phase or wherever and think that you're going to make some kind of a dent in how they process the case, it's just not going to be how it works out.